Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. My name is Kevin Rosenquist, and today we're talking about what happens when life changes after a custody judgment and how parents can ask the court to modify their parenting plan or schedule. Fedor, good to see you. Welcome back.
Good to see you too, Kevin. How are you?
I'm doing good. Let's dive in. When clients come to you asking to change custody or parenting time, what's usually happening in their lives that makes them consider going back to court?
Next question, Kevin. Just kidding. No, like I told you before we started, it was a very long week for me and a very long day. And actually, to answer your question, modifying parenting time in Illinois, what should happen. So there are two stages in child custody sort of litigation. It's pre-judgment and post-judgment. So pre-judgment, it's when people either trying to get divorced, they have kids, or it's a boyfriend-girlfriend relationship, and they want to establish parenting time, custody, child support, stuff like that. Since 2000, probably 16, we have a new law. The law changed in Illinois. I don't remember the exact year now. It's been so long. We used to have what's called custody, and custody would sort of incorporate everything that would, when we speak about children, decision making, where the child lives, or children to this extent, or we don't have custody anymore. So there's only physical custody where a child resides, and we keep this term only for the purposes of others, such as schools and doctors. So the child is assigned to one parent. The child has to live somewhere. There has to be primary residence for a child. So the child has to have his or her own daily routine. He or she has to come to the same, go to bed at the same time, at the same place, preferable. Have the same toys or have friends, go to the same school district. So we don't have custody for a long period of time. We call it decision-making now. Decision-making power as far as major children activities such as extracurricular activities, religion, health, education. But parents then share some kind of visitation time, and that's what we all trying to establish before the judgment. So before people get divorced, or before there's a judgment as far as if there was no marriage as far as the parentage. And usually judges very persuasive as far as litigation process, because especially in Cook County, litigation can take for years. So they want to know where the child's going to live, and that's the primary focus. And then we can talk about division of the property and everything else. But the first thing that we want to do, and we spoke in our previous podcast about GAL, child reps, all of those things. And that's what the judge wants us to do first. The judge wants us to establish everything that is about child. So when we go into that's, I think, where your question goes to. When we go into post judgment, so people got divorced, people moved out, moved on, and now they live separate and apart, and that's when they try to modify and change custody. One thing I want to sort of, in law we call it detour a little bit from your topic, Kevin, is that I had probably 5 consultations this week in regards to this topic, and all of them coming from all famous Chad GPT. And I want to take maybe 5 minutes today and talk about that.
Okay.
So, Chat GPT is all favorable, famous for some reason, specifically in the field of law. You cannot use Chat GPT if you want to learn how to drive a truck. Chat GPT is not going to be helpful to make a diagnose if you have cancer. But ChatGPT tend to be a very common tool for people um, to become lawyers without education, and it bothers me. And it bothers me to the extent that I cannot be silent about it anymore. For two things. First, ChatGPT will never say no to you, and to all the parents out there who came to us or coming to other lawyers or sending us questions or even worse, filing petitions. ChatGPT, if you telling ChatGPT to draft a petition to modify custody, ChatGPT will draft a petition to modify custody. ChatGPT is not going to tell you that you cannot do this and that it's not in the best interest of the child, and it will just draft it for you. You'll sign it and you're going to get in trouble in front of the judge, because remember, ChatGPT is not going to be the one who's going to argue your case in front of the judge.
Very true.
Yeah, and then ChatGPT will not tell you no. That's one of the things that it does. So it's pretty much the same tool as Google that used to be. People would go to Google back in the days in order to get a copy of a contract or marital settlement agreement or allocation judgment, and they make changes. And now even it's for, if you're absolutely lazy, you can just put in the names in the prompt and say draft the marital settlement agreement for me, and it's going to draft it for you. You don't even have to change it. But the problem is that you still have to have some kind of background and knowledge about what you're doing. That's my 5 cents on ChatGPT, to be very careful about it, because I see it all the time for with the pro se litigants. And the problem is that you think that you make it more easier for you. It's really not. I think I don't know how much you pay for ChatGPT these days. The
For the regular one, I think it's $20 a month.
$20 a month, but I heard it's like so even $20 a month, so 12 months, whatever you pay in it, 12 months, right? It's 240. Spend 150 to $200 on the lawyer for legal advice, just to get some background for yourself.
Yeah.
So
ChatGPT is a tool. It's not
huh?
something to ChatGPT is a tool to use in
It's a
certain
tool.
situations,
It's
not
not
to
a
be.
go.
Yeah.
It's not a go-to.
It's not a replacement
We
or anything like
use,
that. Yeah.
I think, the professional version, and it gives you ideas, like where
Sure.
you can start. You can use it to brainstorm.
It's great for that.
Yeah, but you cannot use it as the tool. It's not your virtual legal assistant. Um, just not. And then so many stories already, unfortunately, about some lawyers who would use ChatGPT in their legal research, and ChatGPT tends to give you cases that doesn't even exist, and some lawyers were already in trouble. But that's a completely different topic. For the what has to happen to modify allocation judgment. Allocation judgment in Illinois is pretty much the same as custody agreement that people refer to. So we refer to it interchangeable, but everybody understands what we're talking about. There has to happen some kind of change in the circumstances within first few years. When you After you sign your allocation judgment, after you have a pen and paper, you spoke to your lawyer, there's probably a child representative, whoever you're talking to. You sign the agreement, you file it with court. That's the reason why you go to court. If you divorce, we call it prove up. When you raise your right hand and the judge goes over each and every aspect of your custody agreements, so-called custody agreement, where judge says, do you understand this? Do you understand that? Do you agree with this? Are you entering this, agreement voluntarily without any influence from anybody? And you say usually yes, 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 just because you want to be done and go on. So, well, and that's what I keep telling my clients all the time. Life goes on. You get a better job, or you lost a job. Uh, you find somebody special in your life and you want to move out of state, or your former spouse found somebody and now he or she moves in and wants to live in the same household where your child lives. And that's what, things with children, they're always emotional. I get it. You don't want a stranger be around your child, and especially when the child calls that stranger a dad or mom. That bothers a lot of people. But also, what usually, what really has to happen, if you will go to the very essence of it, something serious has to happen. Like, again, you moving out of state, and you are the custodian of the child, and the custodian, having a child in your life all the time is absolute benefit that you cannot even put a price on it. You spend every day with your child to make decisions about your child, things like that. But then it's a burden. It's a burden in terms of, you have to realize that your life has to be around this child. And if you want to move just because your significant other got a job in the state of Alabama, we just had this case the other day, you have to notify the other parent about your move. And hopefully, this other parent will say yes, but that parent might say no. And it will be very reasonable for him or her to say no, because, I used to see my son, for example, every other weekend. And during the week, I would take him to dinner or play ball with him. Now he's moving away, far away from me, and he's just 8, 9 years of age. I'm going to miss so much, not being able to see him. So a lot of people say no. And if you remember, everything has to be done in the best interest of the child. So what you do, you request permission to move out of state. And if it's not given, you have to go. Uh, Again, the guardian ad litem is appointed. You have to go through this whole litigation process, things like that. The other thing is, in Illinois, still being on the subject, moving to different places, you can only move 25 miles from the previous residence without consent of the other parent. And there are some exceptions to it. But, again, it's all done. If you think about it, it's all done for the benefit of a child. If you have visitation schedule and you have to bring the child, or the other parent has to bring the child to you, and things like that, uh, significant. We don't want children to spend too much time in a car. Depends on the age, of course, but if it's a very little child, small baby, having sit in a car seat for 40, 45 minutes without traffic in Cook County, for example, it's difficult. Or, if the child is older, it's also difficult to spend that much period, so much, time in the car. So there, within this short period of time, so after you sign this allocation judgment, you came to court and you proved it up and you agreed to everything, there's a few years has to pass, with the exception of significant change in the circumstances, when you can make a change to the custody agreement allocation judgment. Those changes has to be really, 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 really significant, such as, besides the ones that I described, unfortunate accidents happen in life, people get into a hospital, people moving out different countries, people being deported, like, God knows what can happen. So that's a significant change in circumstances when you can petition the court and change the custody. If the change is only I cannot even come up with an example, but if the change is my work hours changed, for example, or something like that, it's not a significant change. And the courts anticipate that you, as adults, as parents, would be able to talk to each other, figure it out, and do what's the best for the interest of the child. It's not going to be the court if it's contested. Remember this, by the way. If you agree, if it's uncontested, nobody's going to care.
Hmm.
It's not like, even though it's in the paper and you proved it up and you agreed to it, but then you modified it between the parents, the court is not going to come in and say no, you cannot do it. The court is not going to monitor the parenting schedule. The court doesn't actually encourages that the parents would change things as the things develop without coming back to court all the time. So if you can negotiate and discuss things, that's very much favorable to everybody. And that's what's considered to be in the best interest of the child as well, because children don't want the parents to go to court all the time and fight over some kind of change in visitation, especially when it's minor. If it's 1 hour here, 1 hour there. Unfortunately, divorce is so emotional sometimes, and children in custody is that we see, the child goes to hockey, plays hockey, and now there's a change as far as the schedule for a hockey tournament or practice, and one of the parents says, "Well, it's within my time, so you're taking my time. Why would I do that? I'm not going to do that." And the whole battle happens. So the bottom line here is, first, when you go and sign this document and you go in front of the judge and you say that it's everything to your liking, make sure that that's exactly what you want,
Hmm.
because you might not be able to change it later down the road. People sometimes rush just to be over and done without thinking about the consequences. Second, after you've done this, wait a little bit and see how things will settle. Because even after you're done with your judgment, you divorced, there's some period of time that you have to figure out logistics, how it works, and try to communicate to each other. And then after a certain period of time, if significant changes occur, you can always petition the court for modification.
Hmm. Yeah, well, interesting stuff, and definitely always keeping that best for the child thing in mind is obviously
Yeah,
what
but
people need to do.
don't use Chat GPT too much
Don't
for these
use Chat
purposes, for
GPT.
sure.
Don't use
Because
it.
nobody's gonna tell you in this world what's the best interest of the child. Not a judge, not a child rep, not Chat GPT, not your lawyer. Lawyers and GALs here to give you options,
Right.
and you can select from those options. It's up to you and up for your family how you want to apply it. And then not everything is covered by the statute and by the law and by case law. Every case is unique, and sometimes people approach us for different reasons that you look at them and, like, you can figure it out yourself. You don't need to have a lawyer to go and tell what you need to do. You can figure it out just by picking up a phone and giving another person a call. And I hear all the time, "Oh, he's impossible to deal with." Well, did you try? Did
Hmm.
you actually make that call? Well, not yet. We'll go and try.
All right. Well, that's it for today's episode of the Family Law Frontline. If your parenting plan no longer fits your family's needs, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening. Don't forget to subscribe and leave us a review. So we really appreciate that, and we don't want you to miss any future episodes. Fedor, always great chatting with you. Thanks so much.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.